Sure. Let me start with the obligatory disclaimer slide. I tried to impose this on all of our folks at the agency, but I find it's only my mouth that typically gets the agency in trouble. So we're gonna make sure you know that I don't have an official position for the DFS in anything that I say, or mostly the off-color things that I say. I thought before we started talking about the differences in how we handle federal discovery versus state discovery as Virginia DFS is to talk a little bit about how different I think Virginia DFS is from other laboratories, other state and local laboratories. And that's because Virginia's Department of Forensic Science is an independent state agency. A lot of other forensic laboratories are housed under the police agency, or housed under the state police, or housed under the Attorney General's office. Virginia DFS, since its inception as the Bureau of Forensic Science, has always been housed under non-law enforcement state agencies. And then in 2005, we became an independent state agency. And that kind of bleeds into how we handle things and what our beliefs are. I can't take any credit for it. It is really, our leader is coming to talk to you tomorrow, Linda Jackson, and those that went before her talk about the fact that we are independent and that we consider ourselves neutral and detached from the prosecution team. I would never use the phrase that we're part of the prosecution team. And we are just as open to sitting down and talking with the defense as we are with talking to the prosecutors, which I think is definitely different than I see in a number of other laboratories. In dealing with federal discovery, though, we kind of are beholden to how they operate and how the federal rules are set up. I'll start off by saying that we try never to go to federal court if we don't have to. It's not a good time for our forensic scientists, and I see some people nodding. But inevitably we get caught up in a federal prosecution and we'll have to go to federal court. And so when we are asked by the federal prosecutors to participate, we typically deal with their discovery requests, usually funneling the case file records and anything else that they might want. And it's usually a defense request for those records directly to the prosecutor to disclose. I've also seen SDTs come from the defense, subpoena ducis tecum, where they're asking specifically for us to provide information, and we will respond and provide that as well if it comes that way. In recent months, in December, the federal rules of disclosure, federal rules of criminal procedure, rule 16, really kind of set all of the federal prosecutors on edge because they now have an obligation to write up expert disclosures for our folks. And we moved into working with them, our U.S. attorney's offices in both the eastern and western parts of the state, and how we were going to handle those. And we're working with them on templates on how we're going to disclose that information so that we aren't telling our forensic scientists here, draft a disclosure, because they don't know how to do that. They don't even know what you're talking about. And we basically have worked through controlled substance disclosures, as well as are now working on DNA and firearms, to try to make something so that there is a set pattern to how these are supposed to go to help the AUSAs develop the disclosures, and also so that our folks are just reviewing them for accuracy and not trying to write them. It's also very important to our laboratory that we not recreate a report, because that's something that under accreditation should be tech reviewed. And go through the full gamut of review. So we're trying to make sure that they're referencing the certificates of analysis with the results and conclusions of those forensic examiners, rather than recreating them in those disclosures. The federal prosecutors are a little bit thrown sometimes by the fact that our folks will sit down and talk to the defense. It's not something that all of them feel particularly comfortable with. But we have tried to encourage them that it is actually beneficial to a federal prosecutor to be able to stand in front of a jury and say, you know, the forensic scientists sat down and met with the defense and went through their conclusions, and, you know, they've cross-examined them, and that person is clearly unbiased because they're willing to share information with both sides and to support their conclusions to both sides. And that's a better argument, I think, to make to a jury rather than the forensic scientist is a member of the prosecution team and I didn't get to talk to them, which is where the defense can really go with that. On the state side of the house, just for Virginia rule purposes, so you know how we operate, because I think it's a pretty good framework, is that both parties have access to the certificates of analysis once a charge is made. I have had instances where the defense is trying to get access to certificates of analysis where they're representing a suspect who has not yet been charged. But the statute is very clear that there has to be an accusation made, which I've interpreted, and I think the court would interpret it as formal charges. And then we worked very hard. Virginia just redid their discovery rules, and we worked very hard that rather than doing those expert reports where people are duplicating their certificates of analysis, that our Virginia rules specifically state that the certificate of analysis is adequate disclosure. I sat through a bunch of meetings to make sure that that stayed that way. And the real thought process for the judges and the prosecutors and the defense attorneys that were on that commission or on that work group was that we know we can go and talk to DFS if we have any questions. So as long as we're getting their certificate, that's enough disclosure. If there's anything further that we need, then our Virginia statutes allow for subpoena ducis tecum to come to the lab for records. And we will provide those records to either party. We require SDTs for both parties. The prosecutors can't just walk in and get the records because we want them returned to the court so that both sides have access to them. So the records are returned to the clerk's office. Both the defense and the prosecution can go in and take a look at those. If it is truly overburdensome, which you'll see when we get there, we can ask them to come look at the documents at the lab. Sometimes there are everything but the kitchen sink requests that are overburdensome. And that's a nice feature of our statute that we can make them come review at the local lab. The standard discovery that we're going to provide is always what I refer to as the case file documentation. It's divided into two parts. One is the exam documentation, and that is in essence, what did that examiner use and what is the data that was utilized by that individual to come to the conclusions that are outlined in his or her report. If it's chromatograms, electropherograms, whatever, the Mideo data, whatever might be in that file that would support the conclusions that have been reached by the examiner. And then the administrative documentation is the chain of custody documentation, our request for laboratory exams, which is where law enforcement is asking for a particular examination, and outlining what the evidence are so that they can trace the chain of custody through the laboratory, any court orders, any communications. John referenced email communications. If we have email communications between law enforcement and our forensic scientists or the prosecutors and our forensic scientists, they become part of the case file documentation. It doesn't always sit well. It also is defense attorneys. If defense attorneys communicate, it also becomes part of the case file documentation. So we emphasize to the parties, if you don't want something in the case file, perhaps you should call instead of putting out your theory of the case in the email, or all of the questions you might have regarding the evidence, so that it's not in an MFR or in an email denoted. Additional requests that can come in. The procedures manuals are always important. What are the procedures that were in place for the forensic scientists at the time that they were conducting the evaluation or the exam? Training manuals are sometimes asked for. How are these individuals trained to perform, and did they follow those procedures? Proficiency records are requested. Every forensic scientist at our laboratory for accreditation purposes has to take a proficiency exam at least once per year. DNA examiners have more than that in every discipline in which they're qualified. So they're looking for those results and if the individual has passed that or not. I don't turn over the actual test. Those are purchased from a supplier and they're copyrighted. So I don't feel it's appropriate for me to send out the test and have it put up on the internet somewhere. But I will send them, the emails detailing that, the proficiency test was assigned, the proficiency test was reviewed by staff, and the person either passed, or if there was an issue, what issue was noted. Statement of qualifications, the CV or the resume of the expert. Accreditation records, typically we send out the certificates of accreditation where the lab is accredited every 4 years and each of the regional labs are accredited every 4 years, as well as the scopes and the audit findings. Audit findings can be a little bit more involved. We might make them come review those, but definitely the scopes and the certificates are fairly straightforward. You get a lot of requests on, especially on the DUIDs, which I think are the homicide cases of toxicology, where they want, all the instrument maintenance records, all the calibration records, traceability of the standards, all of those things. They get very involved. We try to limit that to some degree to 30 days on maintenance records, or they can come view them. When I've offered come view in 8 years, I've had 2 attorneys show up to view the records. One was for maintenance records. I'm convinced she had no idea what she was looking at. She just was paging through stuff. And the other was on true allele training records. And that gentleman didn't know what he was looking for and what he was interested in. And so, we make them available if they want them. And sometimes they are on point with what they need. And sometimes it might be an exercise in just papering their file. Corrective action reports. Those are whenever we have non-conforming work in the laboratory. Our accreditation requirements are that we come to the root cause of what that is and to try to put in an appropriate response to that so that it doesn't occur again. So those are pretty important pieces of discovery. Some labs have gone to putting those online. We have not, but we do make them available for the review of the defense and they can request them. Software or instruments used in forensic biology, electronic data typically go to those that have an outside expert, a private expert that they have hired, and they want to review the e-data used by the forensic biologists. And we will make that available to them. We can't make the actual software available to them. It's licensed software. They're going to have an expert that has access to it. John also talked about the source code. I don't have source codes. We don't have access to the source codes. That's proprietary. The SDTs would have to go to the software developer for the source code. We validate that software. So we can provide our validation summaries where we have run, hundreds, if not thousands of samples through that to make sure that it is validated and fit for purpose. But we are not able to give them the source code for any particular software. And then the disciplinary records, if it's pertinent, I think it's very fair game for an SDT. If you've got a disciplinary issue that goes to the individual's handling of evidence, the times when I may say, hey, do you really need this is when, an examiner has been counseled for coming in 3 minutes late every day. I don't think that really goes to, their ability to do their job, nor do I think it's fair impeachment value. And because I would probably be dinged on a regular basis. So, I will call the requester and say, hey, we do have some disciplinary issues. Do I have to, this isn't pertaining, this is kind of what this is. And usually the defense attorneys will say, I don't need that. That's fine. On the Giglio, and Giglio is how the Southerners pronounce it. It's Giglio. You missed your joke. It's Giglio.
So can we do a poll on this one?
Okay.
All right. Any Giglios? Oh, all right. And go ahead and say it your way.
Well, Giglio is how I say it, but
all right.
Giglio is the New York way to say it, is my understanding.
That.
Giglio. There you go. That is the actual correct way to say it.
Any other pronunciations of that word that anyone would like to shout out?
Jiggly.
Jiglio, all right, I came up with Jiglio, I'll admit that. Any other Jiglios?
That's a little close to something else.
And you guys thought ethics could be fun.
This is where I need the disclaimer. All right. So for dealing with Giglio or Giglio or however you want to pronounce it, we do have now that the federal prosecutors have gone to routinely requesting Giglio information under their DOJ policy requirements. I typically get a letter where they're asking me as the newly appointed and least desired title of the Giglio officer of the agency to provide them with any information that I think that might be pertinent for that particular forensic scientist. The most pertinent disclosures that we have to make on that whole huge list of things they request is failure to comply with agency procedures regarding the handling of evidence or failure to follow mandatory protocols with regard to forensic analysis of evidence. Usually when I get those requests, I'm going to review the personnel file, in particular, the evaluations of the scientists to see if there's been any noted problems or if there's been a performance improvement plan or something along those lines. I will also talk to the supervisors to see if they know of anything that might not have trickled up to the main agency branch. And then I'll look for any cars that might be related to that laboratory section or that particular scientist. Has there been any non-conforming work that we've had to deal with? The state or local prosecutors, we've got 120 different elected prosecutors across the Commonwealth of Virginia, and they all do things differently. So I have not begun receiving from them Giglio requests. But what I do feel, even though we are an independent state agency and not part of the prosecution team, is that I'm still an officer of the court. And when we feel like we have an issue, and we also have a forensic duty to correct issues, that I sign off on our code of ethics as well as a forensic scientist. So we do have a tendency to provide and proactively notify prosecutors if there's something that an individual has left, either resigned or resigned in lieu of termination, because there is significant issues with their work. I cannot disclose specifically the information unless that person has given me permission to do so under our Virginia rules. But I will tell them that there's Giglio in the file. You need to file a subpoena or file a court order so that I can provide it to you. If casework is impacted in those situations where we think, cases need to be retested, or this rises to the level of, we might have some concerns with prosecutors that want to disclose this no matter what, then we will send out letters to prosecutors and the law enforcement agencies, depending upon where the case might be, so that they know and have a list of cases that individual worked for their jurisdiction, so that they can go through and review those as well. So, I mean, that's kind of a very broad overview. I think that kind of segues into some of the questions Amie wanted to go through. So I'll stop there and we can go to questions. Okay.
Perfect, thank you. So in some ways, the incentives can end up being somewhat misaligned, right? As a prosecutor, you may want to make sure you have everything that might conceivably be Giglio or Giglio, particularly if you're in the federal system where the judges may have a more expansive view of things, but you also don't want your lab to be completely slammed by these requests or to get packets that nobody ever goes through. I think you alluded to this. So I guess my question would be, are you seeing differences? And I think you suggested yes, between what requests you're getting from the federal system, what requests you're getting from the state. And John, are those sort of issues reflected in the case law, in that maybe the federal courts are taking a broader view of, this idea of the lab's information being imputed to prosecutors, that is all of that Giglio being something the prosecutor absolutely needs to have?
Well, in the Ninth Circuit, the prosecution is obliged by court to look at all the personnel files. That absolute rule is not spread around the other circuits. But I think that, a law enforcement laboratory is going to be considered part of the quote unquote prosecution team for imputation of knowledge purposes. And so that if there is some, some jiggio of greater or lesser extent in the personnel file, and if that is not disclosed, then you've got a problem. So I think that's the direction things are going, and I suspect it's going to come up in the state system when there's some really serious jiggio in the file that doesn't get disclosed. But on the other hand, I think it's probably less and less likely that that's going to happen. So I don't think you're entirely safe in avoiding it, but I think you might want to start thinking about whether you're going to start asking for it.
I think there has to be a balance. The last one I got from a federal prosecutor went even more in depth of, is there anything on that person's social media that might show bias towards the defendant? Do you know anything about that individual's political beliefs that might impact or be used to impeach them? And the forensic scientists, when I forward that stuff out to our folks, are like, are we on trial? And then you've got levels of mistakes. If you're talking about every time anybody didn't follow procedures, that's just too broad. At some point in time, I think you've got to realize it's a corrective action has risen to the level of a serious nature in the laboratory. But if you're talking about, a person 10 years ago had too many technical review forms, and that was noted on their personnel evaluation that they needed to, slow down and do better work. And since that time, they've had this stellar career. Then I don't think that's appropriate giglio disclosure. And I think most of the time the federal prosecutors agree with me on that. I don't think there's much of a dispute on that. But it's a balance that has to be drawn. There's a big difference between what I'm providing to the feds and what I'm providing to the state prosecutors, because the feds are making the inquiries. And I don't know how to remedy that, because I can't just make disclosures for the joy of it. You have to be asked, and people have the right to privacy in their personnel files and that kind of stuff. But at the same time, I think if we could balance it a little bit on what's being asked by all of the prosecutors, that it doesn't have to be down in the weeds. And I don't know how I'm ever going to know what somebody's political beliefs or social media, unless there's been something that's disciplinary. So they're getting really down in the weeds.
Now, if I could interject on that, that sounds like the candid conversation aspect of the federal Giglio policy. We sent a formal request for impeachment information to the agency, and then with all the law enforcement officers, we have, as a candid conversation list of about 20 questions, grows by one question a year probably. One of them is, you have anything crazy on social media? Because the defense is going to do social media searches. That's sort of the analysis. And it could be a pretty uncomfortable conversation, but.
And I think that the social media question may have came about because in the Eastern District of New York, there was a case where it came out on the witness stand that an NYPD officer had posted on his personal, probably MySpace page. This was everyone know what MySpace was a while back, that he learned everything that he needed to know from the movie Training Days. And when this came out for the first time, when he was getting cross-examined before a jury, one can expect that that was uncomfortable for everybody. And I don't think that the case ended the way that anybody would have wanted. So a bunch of these, processes tend to develop based on the last bad thing that happened. That doesn't mean that they're always fit for purpose. And I never asked a lab witness any of those questions, even though I had been sort of trained that we wanted to make sure, in large part for some law enforcement, you might be able to actually keep some of that out with a motion to eliminate and not even have to deal with it in trial. But I never asked those sorts of social media questions for examiners, because I do think there's a little bit of a balance, right? You want to give people their privacy, but you also, as the prosecution, have an obligation to learn this information so that if it needs to be disclosed, it's disclosed. And so that you also have the opportunity to, when appropriate, disclose it to the court, explain to the court why this shouldn't come into the trial, and protect your witness from sort of an unintentionally embarrassing situation. So I think there can be a little bit of a tension there sometimes. And I think it can require, I think, some conversations among offices at a high level to just kind of help us understand where we're all coming from. Ken.
I have a question. I can go ahead and go. So Amy, it's kind of a two-part question. One, does your lab follow the DOJ guidance on the alters with respect to reasonable degree of scientific certainty and the types of conclusions they can make? And if you don't, how do you work with your forensic scientists who know the state process, go into federal court where they're not allowed to say those things?
I think for the most part, our language might not be exact to the alters, but is fairly close. And they work with the prosecutors on what they're permitted to say and not say. The reasonable degree of scientific certainty, if you spend any quality time with a forensic scientist, they'll tell you, we have no idea what that means. So that was one of the first things when I came in as lab counsel, because I was deeply ingrained in reasonable degree of scientific certainty as a defense attorney and a prosecutor coming along. And so it was news to me that the scientists had no clue what that was. And it was every last question that I had. So I had to work with the prosecutors on the state level and continue to work with them on a state level to say, you know, reasonable degree of scientific certainty doesn't mean anything to them. Well, how do I question them? Well, just don't ask the question. You know, it's easy enough. Just ask for their conclusions and rest. It works really well. But I think for the most part, the scientists can work with the federal prosecutors on what they can say and not say, and will follow the direction of the judge as well. So, and they're aware of the alters. So,
and actually, let's go to this gentleman in the middle, and then Robert will come right back to you.
So DC does the same thing that Virginia does and has like we have the same independent GFS, although they're not accredited right now, so that's a different issue. But would you say that because the agency is separate from the prosecution, it's definitely not part of our office, because the AG's office is different from the executive office of the mayor, does that change the obligations that a prosecutor has to get these things? Because you would give them to, they do the same thing you do. Everything they give to us, they give to the defense. So do we have like an ethical obligation to dig deeper than what they give to the defense, or?
The way it works in Virginia is different in that the door is open for them to ask, and if they don't ask for it, then we don't provide it. So
We ask, like, as a matter of discovery, we ask for that stuff, and so they hand us a file, and then they email the exact same file to the defendant.
right. So, but in Virginia, it's only if the defense wants it, and in a lot of cases, having been on the defense side, I never doubted that my client had cocaine, so I really didn't go to look at the forensic science support for that. And my client didn't doubt he had cocaine either. So, you know, not every case do we get a request for discovery. We will get requests, probably, I would say in 10% of the cases that are tried every year in Virginia, they're asking for the file. They're getting the certificates of analysis. Those are provided under Melendez-Diaz disclosures and under the rules of discovery. But if they want to dig deeper into the forensic file, they have to request it, or the prosecutor has to request it and provide it to them.
But John, from an ethics point of view, as a prosecutor, I mean, so if we don't, they're not part of our agency, I don't have any greater access to it than with defense. If the DFS doesn't provide it, what ethical consequences does that have for a prosecutor?
Well, there's a couple of things. The question of imputation of knowledge, like supposing something bad is going on that, you know, doesn't appear in the file. That knowledge may be, you know, imputed to the prosecution, regardless of whether, you know, the forensic service is aware of it itself or passes it on to the prosecution. The duty to dig is a little bit unclear. You can't close your eyes to something, but the court has also said there's no obligation to dig for Brady. And I've dealt with that, struggle with that question. Like, do I have to ask the bank teller, have you been cheating on your wife? I don't think so. I think you start thinking of what is the information that is maybe known to the defendant or may become available to the defendant. I should know about that too. But in like some of the cases that are in my slides, the courts are going to say, we're not going to impose an obligation on a prosecutor. Imputation is really a short way of saying, what the Supreme Court says, the prosecutor has an obligation to find out. What does it make sense to tell the prosecutor you have an obligation to find out? And so I am not sure that there is, an obligation to dig into every potential thing that might have gone wrong in a laboratory if you have no reason to think of it. The Department of Justice's Giglio law enforcement policies, I think, a little bit prophylactic. If you ask for the file, and then you have and you don't get anything bad, and you have a conversation with the agent, and you don't find out anything bad, you're probably okay. And if something comes out later on, that the chemist was, smoking dope or, whatever bad chemists do, then the government is in, a much better position to defend or to otherwise, take corrective action without there being a charge that the government violated a Brady obligation.
Our lab was discredited, I think, for the false certification because they were falsifying analysis in the firearms agreement. And so both the U.S. Attorney's Office and the Attorney General's Office sent letters to the defense bar saying, here's what the IG recovered. And then we went through and did an analysis of every case that any analysis provided these things. Then we provided those counsel with
exactly
specific notice
on a shorter timeline than those disciplinary cases that I have.
Well, yes, I mean, they did that. I guess they read that case. But I'm asking in a general sense, like, really, does it change the calculus because they're independent?
No, I don't think. I think that the fact that they're independent, is helpful for cross-examination. But I think the court will say that knowledge that should have gone to the prosecutor is imputed to the prosecutor, or conversely, the prosecutor should have found out this information. We're talking about post-trial Brady motions, and the judges are reluctant post-trial to find, to find no mistake. At least my observation is that they find everything to be material. So I think your obligation as a prosecutor is you do stuff that makes sense, maybe go a little bit beyond what makes sense, but you don't have to launch a separate investigation to every one of your persons. And 99% of the time, you're going to be okay because they're doing the right thing.
I think the better practice is sort of what Amie, it sounds like, already has going on with the lab, right? If there's a failed proficiency test, if there's something that the lab believes to be sort of material to the credibility of the witness, to the witness's skill in carrying out the analysis, any of those things, I think the better process, in part, even if it isn't imputed to you, your job is to understand whether there are issues with the evidence too. Right. So I think that, but it seems like Virginia has sort of struck a thoughtful balance between making sure that information is provided, but also not giving everyone what a phone book is, like an entire, just a huge, massive material. So I think, and we're all at the mercy of what a court determines. And you're right. I mean, it's certainly a factor if a lab is not within the prosecutor's office in determining whether a court is likely to impute knowledge to the prosecutor. So I think that's certainly a good factor for if there is some issue, that information you should have gotten, you didn't, that could have been turned over to the defense. We've got.
But the question I have is, you're still a state agency. It's still state action in a manner of speaking. You are the government. And so it seems to me that it would always be to us, because you are a government agency. I speak from experience, just being a practitioner in Massachusetts. We had the Jenkins scandal.
And Sonia Farrick.
State laboratory.
Yeah.
We had a subsequent, Sonia Farrick case involving, a drug analyst that was doing drugs and someone, it's a case presently pending an accident case report the prosecutor would have disbarred because she decided that it wasn't necessary in this particular case to disclose certain information about the Kenneth's drug addiction. And I just see that the way that the courts are looking at this is they're always going to impute it to us, and that we have an affirmative obligation. Our lab is part of the Department of State, so it's obviously imputed to a government agency. But you're still a government agency, so I don't know how you get around, not having more of an affirmative.
I mean, John, in the Second Circuit, and John alluded to this case, there's a case that involved a Secret Service expert. And even though that expert was certainly part of the US government, part of the same federal authority in theory that included, the US Attorney's Office, that court still did a very case by case or a very nuanced kind of factor by factor analysis to conclude that Secret Service expert was not in fact a member of the prosecution team. So it can be, and I also think that courts are all over, and I'll let John chime in here, are not all of one voice in kind of how broadly they draw the sort of lines around the prosecution team. There are also efforts at sort of a national level to kind of increase the idea of imputation. And do we have any New Yorkers here? There's a New York discovery statute that broadens extensively the discovery and disclosure sort of requirements for forensic science evidence and in some other spaces too. So I think the prudent thing to do, and perhaps in Massachusetts and some other states that look at these things more broadly, the necessary thing to do is to sort of think of the lab as a member of the prosecution team, just so you're checking all those boxes, right? Then you've got the information, you've got the Giglio, you've got the Brady, and you can do the right thing. Then I think you save the analysis of whether the lab is in fact a member of the prosecution team for those instances where things went wrong, where you find out after the fact that in fact something bad was happening, or you didn't get the information that you need. And I think that's again, I think the prudent thing to do. You may be able to argue that they are not a member of the prosecution team for this sort of imputation analysis, particularly when it is an independent lab. I think you're on better footing for that. But the safer thing to do is to try to get the information, try to turn it over, and again, save your arguments for the cases where somehow things went wrong.
I don't disagree with you. I think we are the government. So if we've got an examiner that has had to be terminated or has resigned in lieu of termination because of issues, we disclose it. I don't want to be on the receiving end, and the risk analysis is far more damaging to us to try to withhold that than it is to just be upfront and say, this is an issue. If we had a Sonia Farrick or an Annie Dukin, and I need wood, but if we had that happen, I would have sent out immediate notifications on that. It's easy for me to Monday morning quarterback too. But to me, that just is clear cut that everything they've ever touched is in question. And the better choice of the lab is to be transparent about that and bring it to everybody's attention.
Let's just say that the Massachusetts State Neutron Lab is excellent. It's the fact that it was an unaccredited Department of Public Health lab that made it.
Right.